Good afternoon, Facebook folks. For those of you that don't know, my name is Jacob Stidham. I'm a partner here at Banks, Stubbs, and McFarland. This is my first live stream, so take it easy on me in the comments. With everything going on with the COVID-19 pandemic and all the interruptions it's causing to our daily lives, we thought we'd take a few minutes to talk about the way the court systems are being affected. Many people are aware, but some may not be, that back at March 13th, the Supreme Court of Georgia issued a judicial emergency order. And what this order did was put certain restrictions in place on what local courts can and can't do. The original order was only supposed to go 30 days, but as it got near the end, it became apparent that the pandemic was going to keep going and was not near a point where everyone was comfortable resuming normal activity, so it was extended a further 30 days into May. Where that leaves us now is trying to figure out what courts can be navigated, what cases can be heard and can't be heard, and how we should go about doing that. So we'll take a few minutes to kind of talk about that and go through what's going on. The way the order is worded from the Supreme Court is that only critical or essential functions which protect the health, safety, or liberty of citizens can go forward. And the court initially gave a list of things that was not an exhaustive list, but a representative list of what the Supreme Court felt were things that needed to keep going. Those included search warrants, arrest warrants, the hearings that have to happen to issue those, things like protective orders, which are obviously involving the safety of individuals, things having to do with juvenile court detention. It's very important that when someone in juvenile court is being taken into custody, that they very quickly go in front of a judge for determinations on whether they should be left in custody or not. So those absolutely need to go forward. In addition, in juvenile court, things like emergency removal hearings, where you have a child that is deemed potentially at danger in their home, it's obviously very important that those also go forward. As we move on, things like determination of mental health capacity and commitment. If you have somebody that someone believes is a danger to themselves or others and they believe a civil commitment order is necessary, those are also considered essential. The most interesting one that we see that is on a lot of people's minds is jury trials. What we are seeing is that all jury trials are currently canceled. Jury trials are considered essential to liberty, but not essential to the functioning of the courts at the moment. Biggest reason being, we don't want judges, prosecutors, defense attorneys, defendants, and most importantly, jurors and witnesses all being packed into courtrooms where there's not typically going to be sufficient spacing available to maintain a proper social distance. And so the Supreme Court has determined that all jury trials have been canceled. They're canceled for March and April, and based on the way things are going, most jurisdictions have canceled them for May as well. And there's actually a distinct possibility with the way that calendars work and the way that preliminary matters have to be heard, adjudicated, and things need to be sorted out as far as calendaring, that June is likely going to be canceled as well. So we're looking at possibly July, if we're being honest, about when jury trials may be able to resume again. I work in criminal defense. That is the main focus of my practice. So for today, we're going to focus mostly on how criminal defendants, prosecutors, and judges are dealing with these sorts of cases, but we will touch on a few other things as well as we continue to go. What does an immediate liberty or safety component mean when we're talking about the world of criminal defendants? What that means is things like bond hearings. If somebody is in custody, that is an essential liberty interest at stake. And so bond hearings are going forward. Now, the way that bond hearings are happening in most jurisdictions that we work in and that we're hearing is now by video conference. So I know here in Forsyth County, the judges have decided that Microsoft Teams is the video software that they want to use. Other courts that I'm working in have used Zoom. I've not heard of anybody using Cisco WebEx now, but I know that's another option out there. And what is happening is you essentially end up with defendants that are in custody being brought into a video relay room, a courtroom in the jail that has a video relay set up. You'll have a judge in chambers on a video. You'll have a prosecutor, typically in their office or possibly even in their home, depending on where they're working from, on a video conference. And then we as defense attorneys, typically in our offices is how I've been doing it, also on a video relay. And so you have a bond hearing, and you're trying to do everything you can to get people out of custody during this time, especially given that jails are not known to be the most hygienic places. And there's a risk that in a tightly packed population, if the virus were to make it into the jail population, it would probably spread very, very quickly. And so liberty interests with bond hearings are a big thing that we're working on right now. Related to bond hearings are going to be first appearance hearings. First appearance hearings are also essential liberty interests at stake because oftentimes on lesser charges, not serious felony charges, bonds can be set at those first appearance hearings. And the way those have been happening in Forsyth County, at least, is there is a separate room in the jail that defense attorneys are going to for purposes of being on the video relay system. The inmates are being brought into the courtroom at the jail, and then the judge and the prosecutor yet again will be appearing from chambers and their offices. And we have these first appearance hearings. Other counties, Cherokee, for instance, I had one recently, is operating more like the bond hearings where the defense attorneys don't have to show up. They can just ring in through their computer on video conference as well. And everything seems to be going forward from that point on. These hearings, for the most part, are relatively straightforward, and so it is more easy to have these types of hearings by video conference. Now, related to a bond is what might be a bond modification. Oftentimes, there may be conditions placed on a bond that, as a case develops, may no longer be necessary or required, and so where we end up with is a motion to modify those bond conditions or change them. Those hearings are not considered essential because the person who is out on bond is no longer in custody, so their liberty from that perspective is no longer being restrained. Now, certainly if you have a loved one where a bond condition is you're not allowed to see or talk to them, you may consider that very much a essential function and an essential restraint that you want lifted, but from the court's perspective, you're not actually physically in custody, and so those motions are being reset until such a time as we can safely handle them in court. Another essential function that we have to think about is driver's licenses. These mostly affect DUI cases, and what we have found is the Office of State Administrative Hearings, alongside guidance from the governor and the Supreme Court, have canceled all in-person hearings until at least May 31st, and June is still up in the air. However, these are not considered an essential safety or liberty interest, even though in a modern society, functioning without a driver's license is exceedingly difficult. And so where we end up with is the state administrative office is offering the option of video hearings. However, these hearings can often be very contentious, and they're the type of hearing where we as defense attorneys are typically going to want to be in the courtroom with the witnesses, in order to ensure that the judge is giving proper deference to our questions, but also can properly assess the demeanor of the witness, the knowledge of the witness, the body language, eye contact, things that are very important, which can be skewed by a video hearing. And so what we're seeing is that even though the administrative office is offering video hearings, we're seeing very few attorneys take advantage of that. Rather, they're asking for continuances in order to ensure that the judges are giving the proper deference to the case that it needs. And what that's resulting in, for the most part, is people who are able to temporarily keep driving until such time as the administrative office can open back up for in-person hearings.